Is court ready?
I'm fine now, thank you very much.
The matter of Waltham Borough of Waltham.
Yes, Miss Gallagher. Thank you. My lady, my lords, may I start with a wardrobe malfunction? In these days of Zoom, I'm not addressing you as a cat, but I am addressing you in circumstances where we have one wig between council. And my apologies for that. A failure in our reasonable system of wig transportation, it's fair to say, although we had a 50% hit rate. A little different to the figures we'll see today.
I won't worry about that at all.
Thank you, I'm very grateful, my lady.
We're just very glad that we're here in person, and we're grateful to everyone feeling comfortable coming into the court, because we certainly are of the view that everyone gets a better hearing.
We're very grateful, and thank you for accommodating it. And also, this is a case of wider public importance, and it's helpful that it can be live streamed and that the public can see the issues raised.
Yes.
We did take the view on the wig issue that it wasn't appropriate for a clerk to come in unnecessarily. We're grateful.
You know, really, I think that's the least of our worries or concerns today. So
thank you, my lady.
But thank you for being so courteous as to raise it.
Thank you. My lady, I of course appear for the appellant in this matter, Ayor, who was a child at the time of the events in this case, aged 16, and is now a young man of 19. And I appear with my learned junior, Mr. Sam Jacobs, instructed by Miss Jennifer Twite of Just for Kids Law. And my learned friend, Mr. Ashley Underwood, Queen's Counsel, appears for the respondent, the London Borough of Waltham Forest. As you'll have seen from the papers, there are 4 interested parties, none of whom are in attendance before the court today. The court has their submissions and evidence from the Divisional Court in a supplementary bundle. Before I start my submissions, we have some housekeeping matters to deal with.
Yes.
The first is, you should have 3 bundles, a core and a supplementary bundle,
yes,
and a single and admirably lean, I hope, authorities bundle.
Yes. Considerable relief after yesterday, let me tell you.
Yes, we can imagine. And we've attempted, this is an unusual situation because in essence, the issues before us relate to a small number of paragraphs in the Court of Appeal's judgment. So we've kept the authorities lean, and we're mindful that there may be issues which arise which require us to send additional authorities, and if so, we'll do it. We do have 2 new authorities today, and I don't know if they've reached you. The first is a new tab 15, the Begum case. The second is a new tab 16, In Re B. And my lady, you in particular may be familiar with that. That's a family division case which came to the Court of Appeal about Section 25, secure accommodation. And we've provided it simply because there's 3 paragraphs from the Court of Appeal relating to that. We do have hard copies in plastic slips, if they can be passed forward.
Yep. Well, I've got Begum, I don't know.
Yes, I've got it.
Number tab 15?
We do have a new authorities index also. And may I pass forward the
Please
hard
do,
copies?
that would be very helpful.
I have, but not the other case.
Thank you. They're in a plastic slip.
Thank you, that was considerate.
And there's the corrected index as well for slotting in.
Thank you.
Still only taking us to 16 authorities, which we hope is helpful. There's then 3 other new documents. We've got copies of these also in case they haven't reached you. There's the respondent's application to file fresh evidence, dated the 23rd of June 2021. The fresh evidence itself, a statement dated the 22nd of June 2021. And then there's the Secretary of State.
Mr. Phelps' statement.
Yes, that's correct.
Yes.
Does the court have those?
Yes. So what we've got is we've got the application to adduce fresh evidence referred to section 6 in the skeleton.
Yes.
We've got the application to file Mr. Phelps's witness statement in response, and we've got the GLD's letter of the 28th of June on behalf of the Secretary of State.
Yes, and with the GLD's letter for the Secretary of State on 28th of June, there should be this document, Secure Children's Homes, Capital Programme 2021-22, June 2021.
Yep, I have that.
We do have copies, my lady, if helpful. Should we provide them in case there's a difficulty?
Yes, if I can just say, speakers, so that just to save time, we've had an opportunity of just briefly discussing this between ourselves, and I think rather than getting bogged down in disputes about land marshal and so on and so forth, we would prefer to just get on with the appeal and then look at this material de bene essay, and we'll give our reasons if necessary for why we do or do not take it into
I'm grateful. I was going to ask if the court wanted us to deal up front. No, because there's two applications for fresh evidence. There's the one from the appellant,
yes,
which was not dealt with at permission stage.
Absolutely, it was adjourned over
and remains, precisely, and we've dealt with that in writing. And of course, you'll know the background to that and how that evidence came into being. And then the second issue is the new statement from my learned friend.
Yep.
If you don't want to deal with that up front, we'll deal with it as it arises.
I think we're all agreed that we don't
Thank you. My lady, my lords, there's just one other small correction while dealing with housekeeping that I should just make, and that is typographical error, which is entirely my error. In our skeleton argument, it's page 16 of the bundle, paragraph 1.3, line 5. It refers to section 25 of the Children Act, 1989, at the start of that sentence. Should, of course, be section 21.
Yep.
And my apologies.
Not at all.
So, bearing that in mind, I intend to start with a summary, and I'll give you a roadmap of my intended submissions. I should say, myself and my learned friend anticipate we're going to be relatively short today. We don't, in fact, think we'll take the whole day,
no, well,
given the shortness of the issues, and particularly if you've had the opportunity to review the papers in advance.
We've read all the papers, we've read your skeleton arguments, and I know that we've dipped into the authorities and the supplementary bundle as and where necessary.
Thank you. And so by way of summary, the appellant appeals against the order of the Divisional Court dismissing his claim for judicial review. And as you know, the judgment of Lord Justice Davis and Ms Justice Andrews was handed down on 16th of March 2020. It's very shortly, in fact, before lockdown commenced. The judgment is at the core bundle tab 6, commencing at page 49. But there's only 2 pages of it, essentially, which this appeal turns on. And the order is at tab 5, pages 47 to 48. And as you'll have seen, permission to appeal was granted by Lord Justice Noogie by order of 12th of November 2020. That's in the core bundle, tab 15, page 143. And as I'll come to in 3 sentences, Lord Justice Noogie encapsulates precisely what this appeal is about. This claim for judicial review concerns children charged with an offence and denied bail, for whom the police request secure accommodation placements pending their first appearance in the criminal courts. So unless it's at a weekend or a bank holiday, that will almost inevitably be a very short-term time frame prior to first appearance the following day, the following morning, or a number of hours later when the courts open. And this case concerns the lawfulness of the respondent, the London Borough of Waltham Forest system, for meeting requests made of it by the police to provide secure accommodation for this particular group of children. Now, before I start my submissions proper, just summarise the core argument advanced by the appellant and the route I propose to follow in my short submissions today. The appellant, Aor, then aged 16, was detained as a child in a police cell post-charge in 2018. The Metropolitan Police, one of the interested persons, contacted the London Borough of Waltham Forest to request secure accommodation, which the local authority could not meet. Now, this appeal, as you'll have seen, is not about the specific events in 2018 relating to this specific child. It's about whether or not the local authority has in place a reasonable system for responding to such requests for secure accommodation under Section 38. In other words, whether it meets what is commonly referred to as a local authority's Gateshead duty. That's a phrase you'll have seen in the Secretary of State submissions below, supplementary bundle, page 435, paragraph 11. I should say, I don't intend to turn up documents unless key. I'll give you the references. Requests are made by the police pursuant to section 38(6) of the Police and Criminal Evidence Act, which requires custody officers to secure that a child charged with an offence but remanded is moved to accommodation provided by the local authority rather than being detained in a police cell pending their first appearance. Now, a request may be for either secure or non-secure accommodation, and concomitantly, Section 21 of the Children Act, rather than Section 25, then imposes a matching, interlocking duty on local authorities to respond to those requests. And there's a distinction between the local authority's obligation in respect of non-secure accommodation and secure accommodation. For non-secure accommodation, it's an absolute duty. It's akin to the Section 20 Children Act duty. So if the request is made, the need is met, it must be complied with. But for secure accommodation, it's a little different. It's a discretionary power to provide secure accommodation when it's requested. As you'll have seen from the authorities bundle and the background, the Court of Appeal made clear in the leading case on this issue, Gateshead, 15 years ago, that that discretionary power to provide secure accommodation must be exercised consistently with the statutory objective that children should not be detained in police cells if at all possible. And to that end, local authorities, in exercising that discretion, must at least have in place a reasonable system to meet requests for secure accommodation. We'll come in due course to Lord Justice Dyson's analysis, but that's paragraphs 42 and 43 in tab 8 of the authorities bundle. And in summary, the respondent system, which it maintains is reasonable, is that it has a system for answering a phone call made by a custody sergeant, whether it's a secure or non-secure request. But when the request is for secure accommodation under section 38(6), the answer to that request, when the custody sergeant places the call, will almost inevitably be no. There's not a single instance in the papers before you of the London Borough of Waltham Forest ever providing a section 38 secure bed when requested by the police. And in fact, the evidence shows the inevitability of this, the inevitability of the no when the call comes through, given the shortage and geographical location of the only potentially available, in theory, secure placements. And our submission, in essence, is that this is simply not a reasonable system for the provision of secure accommodation pursuant to the interlocking provisions of Section 21 of the Children Act 1989 and Section 38(6) of PACE. It may, of course, be a reasonable system for managing telephone calls. It may, of course, be a reasonable system for informing custody sergeants of the inevitable negative outcome to their requests and getting confirmation that the answer is, yet again, no. But in our submission, it is not a reasonable system for meeting the custody sergeant's requests. Nor is it a reasonable system when measured against the statutory object and purpose that children should not be detained in police cells if that is at all possible. The correct statutory object and purpose in our submission, summarised by Lord Justice Dyson at paragraph 42 of the Gateshead case. It is not consistent with the basic administrative law principle that any statutory discretion must be exercised consistently with the objects and purpose of the statutory scheme. And when you see paragraph 43 of Gateshead, which refers to the need for a reasonable system to enable them to respond, that's the description given by Lord Justice Dyson of the system which it is incumbent upon all local authorities, including this local authority, to comply with their Section 21 duty. We say a reasonable system to enable them to respond means substantively respond, not answer the phone and say no. That's not a reasonable system. And in essence, our argument is encapsulated in the 3 sentences at the outset of the permission decision, which you'll find at page 143 of the core bundle, tab 15, when Lord Justice Newgee said, in the Gateshead case, the Court of Appeal said at 48 that the court should be slow to strike down arrangements as unreasonable, should do so only if satisfied that no arrangements have been made at all, so that they can never provide secure accommodation if requested. The evidence is that for practical purposes, London boroughs, including Waltham Forest, can never, or virtually never, provide secure accommodation when requested. It's doubtful that this is what Parliament intended. So that's the essence of the case which the respondent has to meet. Now, in essence, the answer of the London Borough of Waltham Forest, and accepted by the Divisional Court, was this is a nationwide problem. It's not specific to this local authority. So it contended the problem is a nationwide shortage of secure accommodation, which it is not for it to remedy, and it relies on its system, what it describes as its system, of relying on the national mechanism for accessing the extremely limited supply of secure accommodation. It says that's reasonable. That's the SAN system that you'll have seen. That SAN system is a referral system. It's not a system for the provision of secure accommodation. In fact, as we'll come to, there's only 15 placements across the country for secure accommodation, 14 of them provided by other local authorities, unlike Waltham Forest or other London boroughs, who have provided secure accommodation, one provided by a charity. And the judgment in paragraph 72, which we'll come to, accepts that core proposition from the respondent. And in our submission, that's to fundamentally misconstrue where Parliament has placed responsibility for the provision of secure accommodation and to fail to give effect to Parliament's approach. And as I'll explain, in our submission, the responsibility statutorily falls squarely with individual local authorities who can, if necessary, liaise with neighbouring local authorities and who can, if necessary, apply under Section 82 for funding from central government in order to comply with its obligations. And there's no evidence, again, before you, of the London Borough of Waltham Forest ever making such an application under Section 82, and which is why both we and the Secretary of State simply disagree and say there's no proper evidential basis for the Divisional Court in paragraph 72 of Miss Justice Andrews' judgment, laying the blame at the door of central government, saying this is failure on the part of central government to fund the system, because there's no evidence of any request ever made by this respondent for funding under Section 82. In our submission, we have a situation here where the respondent has simply failed to comply.
Can I just ask you about that?
Of course. I realise I'm doing a rather long introduction.
No, that's all right. And I don't want you to answer questions out of order at all, so it may be that you want to come back to this. But one point that I would like your help on at some point is, suppose we were to accept that strand of your argument, and I'm not saying we will, but just to test the argument, that they've acted irrationally because they have not so far made a request for funding to the Secretary of State. But suppose they then go away to comply with the court's judgment, and they do just that, and there's still no funding. Objectively speaking, the arrangements on the ground would not have changed. But would that mean that something which we said was an irrational system would then become a rational system?
Thank you. I will come to that in some detail when I turn to those provisions.
Thank you.
But it's a timely question, as you'll have seen from the 28th of June letter, because of course there is an upcoming deadline for applications for funding. In fact, next week, you may have seen that from the attachment to the GLD's document setting out that I think it's 5th of July, 6th of July, in fact, a week's time, there's a deadline for the submission of proposals. And of course, none of the evidence before you suggests that there is an application being made. There is material to which I'll come relating to a 2019 options paper. But as I'll show you, and as indeed my learned friend accepted quite rightly in the Divisional Court, that options paper doesn't deal with Section 38 beds. It only, in fact, deals with other types of placements, welfare placements and criminal justice placements. But my Lord, if I may, I'll return to that question when I get to that part of the submission.
Yes, of course.
and I will not forget it, and do remind me if I have. So in terms of the roadmap...
Sorry, can I just ask you to put it in context? You may be coming on to this too. But if we deal with these Section 36 PACE cases, and we have, you say there are 15 secure accommodation places. There are other areas, of course, where secure accommodation is required. Is it only 15 places across the board for all secure accommodation requirements, or is it only PACE requirements?
No, it's 15 secure children's homes for all requirements.
All requirements.
And in fact, the evidence before you shows that many of those placements simply don't accept Section 38(6).
Well, that's what I wondered, actually. I mean,
precisely right.
It doesn't follow that there are 15.
No, it doesn't. So one of the oddities of this case, if I might put it this way, is, and you may have seen this from the paper trail in the supplementary bundle in particular, that our instructing solicitors at Just for Kids Law, who have particular expertise in this, were concerned about the absence of a system. And you'll see the evidence which was before the Divisional Court about the system came predominantly not from the local authority, but in fact from Just for Kids Law, in the very powerful statement of Alex Temple, who rang around to check and then is able to give evidence about particular placements who say we won't accept a Section 38 placement. And that's where the reference to Hailsham comes, because there's the reference to, geographically, it looks as if Hailsham is the closest. Alex Temple attempts to reach them, can't get through. And that's why I referred to open justice earlier. After the hearing the last time, when the local authority relied very heavily on the geographical distance between London and Hailsham and how you compare that to Gateshead, a journalist in fact contacted Just for Kids Law to say the court proceeds on that basis, it's factually flawed. Because in fact, we tried to film at this unit and the unit said we don't accept Section 38 beds from outside the area. So one of the difficulties with the material is in fact that the local authority has not provided detailed evidence of the system. So you've got piecemeal evidence from Just for Kids Law doing a very diligent job in the absence of an evidential picture on the other side. And then from the Metropolitan Police, the statement of Anne-Marie Bullivant in particular, Secretary of State for Education, and the other interested persons. But that is a particular difficulty here, that in fact there isn't a clear answer in the papers before us about how many of those 15 units will accept Section 38(6) referrals and will accept Section 38(6) referrals outside area. It's certainly less than the 15.
Just to be clear, we are talking about 15 units. We're not talking. You've interchangeably said places, placements, and units.
I'm so sorry. It's 15 units. Yes.
So some of those will actually are relatively large, with quite a large number of places, and some very specialist ones are perhaps only 1 or 2 children.
Yes, that's right. And one of the reasons why we brought the authority behind tab 16 is that we thought the court may be aided by looking at the line of case law in the family division, and which has come to the Court of Appeal, over the last number of years, relating to the shortage in any event of this type of accommodation. Now, this doesn't relate specifically to Section 38(6), but I may just take this out of order given that the question has arisen. It's just 3 paragraphs of the authority behind tab 16. And this is Lord Justice Baker in Ray B. You'll see it's a recent judgment reported in 2020. It's 2019 EWCA 2025. It's paragraphs 4 to 6. Commences at page 227 and goes over the page to 229. And that refers to the general context. And if I may just take you to those provisions as we've turned it up. I want you to have to turn up authorities more than once if I can help it. And it says the context in which that appeal was being considered, which is a Section 25 case about a 15-year-old girl. The context in which that appeal was being considered is what can fairly be described as the crisis in the provision of secure accommodation in England and Wales. That was the subject of comments and expressions of concern the previous year in the case of In Re T. And you'll see the powerful words of Sir Andrew McFarlane, the President, quoted in paragraph 4 about a growing disparity between the number of approved secure children's homes and the greater number of young people who require secure accommodation. And then you'll see paragraph 5, in the 12 months since In Re T was decided in 2018, there's been no improvement in the provision of approved secure accommodation. On the contrary, the position seems in some respects to have become worse. And then paragraph 6, the Court of Appeal referring to the significant shortfall in the availability of approved secure accommodation, causing very considerable problems for local authorities and courts across the country. And reference is made, we haven't given you all of these authorities, and we're conscious that the court will be aware of them. There have been a number of expressions of concern. So that's the wider context. This is a particular subset.
An issue that we were going to raise at the end of the hearing, but I'll raise it now as it's, as you've referred us already to Re B. I presume that Re B was chosen as the most recent.
Yes.
But you'll see at paragraph 5 there's a reference to Re T,
Yes.
which was they referred to the 12 months before. And I don't know if you are all aware, but the Supreme Court heard the appeal from Re T in October of last year. I've made inquiries with the Supreme
Yes.
Court this morning, and it's hoped that that judgment will be handed down before the end of this term, so before the end of this month.
Ah.
Now, we know not whether or not it will be of relevance to your submissions, or either of your submissions, I should say, or not, because it's a slightly different matter, because that's a case where what the local authorities have been doing in the absence of being able to find statutory placements is
Yes.
they've gone to the court to exercise their inherent jurisdiction
Yes.
in order to place children in unregistered secure placements. And that is the issue before the Supreme Court. Now, of course, no one has the faintest idea which way the Supreme Court will go. But if they said that that was illegal and that should not be happening because of the statutory requirements, it may be that they may make observations which either of you may want to comment upon. So it seems to us that if the judgment is handed, it's not directly on point. So it seems to us that if the judgment comes out this term, then it may be that we'll look at it and wish to give each of you the opportunity of making some short additional written submissions. If, however, it seems to us completely irrelevant, or if it runs the full 12 months and doesn't come out till the autumn, then we don't think it's appropriate that this
Yes.
case, that is likely to be so relevant that it would be appropriate for us to wait.
My lady, may I just give you an indication of our likely position, and I'll take instructions later and come back to you if there's anything further, but just immediately while you've raised it. It seemed to us that a line of authorities with the, if I can put it this way, alphabet of vulnerable children making their way through the family division and into the Court of Appeal and then ultimately to the Supreme Court on the Section 25 inherent jurisdiction issue, seems to us that the observations of the courts in those cases are relevant as context setting for the issue we have here. Now, essentially there what you have, as described by Lord Justice Baker in the most recent Court of Appeal authority on the point, is what's described at page 229E, just below the quote from Mr. Justice Holman in Re a Child, where he referred to being increasingly concerned about the divisive resort to the inherent jurisdiction getting around the Section 25 shortfall. It's then said by Lord Justice Baker, the absence of sufficient resources in such cases means that local authorities are frequently prevented from complying with their statutory obligations to meet the welfare needs of a cohort of vulnerable young people who are at the greatest risk of harm. And what you then have is the inherent jurisdiction mechanism. Now, the inherent jurisdiction mechanism may be able to get you a relatively speedy result in a welfare case where there's a need which is ongoing, maybe ongoing for weeks, maybe ongoing for months.
It's not going to be any use for
It's
overnight.
hopeless in this case, precisely. So it's important because if the Supreme Court echoes the concerns that we've seen in a series of cases, I'm conscious, and Lord Justice Peter Jackson as well has expressed concern about this, and there have been a number of expressions of concern extrajudicially about this issue. If that's echoed, it simply reinforces our point, because at present, that case law shows that there is a fundamental shortfall for all secure accommodation. This, my lord, is the 15 units, not placements, the 15 units across the country. There's a severe shortfall in relation to welfare placements. And there's three types of placements which can be made as secure accommodation. There's first of all welfare placements, secondly criminal justice placements, and then thirdly these very short-term Section 38(6) children, where at most you'll have a Friday night referral with a bank holiday taking you to a Tuesday morning at most. And usually you'll have, as you had in Gateshead, a 20 minutes past midnight call for a first appearance the following morning at 10 a.m, or as you have here, an afternoon the previous day call for a first appearance at 10 a.m. So usually you'll have a period of 12 hours, and at most you're going to have 2 days. So the inherent jurisdiction get around, lawful or not, doesn't help in these cases. And as I'll show you, in fact, when you look at the steps which have been taken, and which are limited too little too late, in our view, and in the view of that line of case law from the family division, the vast majority of them are focused on welfare placements and criminal justice placements, and not on this particularly vulnerable cohort of children. So it seems relevant to us in terms of context setting, but actually, regardless of the outcome, shouldn't affect whether or not there's a reasonable system in place presently. I should say, I'm conscious that for other reasons, I believe the Supreme Court is adjusting the days on which it's handing down its judgments for COVID reasons to a Friday rather than a Wednesday. So if there is to be notification, I think the timetable's a little different to usual. So perhaps if we're thinking about potential for further submissions, we should bear that in mind. End of term is imminent, but if it's due to be handed down, my lady, as they've indicated, it's quite likely to be a Friday.
I think describing it as an indication is a little strong. I think it's an aspiration.
Yes. Well, certainly your intelligence is better than ours. We'd no idea how long it was going to take. And having been a veteran of the benefit cap case where the delay was over 12 months, I think you won't be surprised that we hadn't taken a view on how long it would take. That was rather a long introduction, but I hope helpful.
I'm sorry.
Yes, of course.
I'm sorry to prolong the introductory part of your submissions, but it may. I hope it'll be helpful if I just flag up one or two questions that I would like your help on, and then by all means come back to them at the appropriate juncture in your order of submission. The first really flows from what we've just been talking about, and I'd like to get a better feel for my part on what in reality would be required in order to deal with the realities of the court's needs, for example. I mean, there's been talk about Hailsham and so on, and that may be significant, I don't know. But if we're talking about London courts, where I, of course, have sat in the past, the reality of the situation is that you're going to need someone well before 10 o'clock, if that's the start of the court day. Quite often, certainly from my experience of sitting in the Crown Court, we would find that people were having to be brought from prisons, for example, or young offenders institutions, at times when it meant that they couldn't have breakfast. And quite often they wouldn't have had dinner, certainly not a hot dinner, the evening before. So I'm just wondering what the practicalities are going to be if there are more secure accommodation placements, and whether really, in the real world, are they really going to be in the best interests of children, as compared to a police cell, however unsatisfactory that may be in principle. Because and this really leads me on to my second question, and I don't know the answer to this, but if we were to say, at your invitation, that the current arrangements for PACE requests are irrational, would one potential consequence of that be that there would be fewer places in principle for the other kinds of placement, like the welfare placements? I don't know the answer to that, but could that be one practical knock-on effect of what we say? And really the third part of my question flows from that, which is, do we have to be careful? Because inevitably in litigation, what we see is one small part of what may be a larger mosaic. We don't know what the knock-on effects of a decision in the court may be on other children, on other demands on public authorities' finances. And so at some point,
Yes.
speaking for myself, I'm going to need your help on whether it's really as straightforward as saying, find this local authority's current arrangements are irrational.
And my lord, I've taken a careful note of those questions and I will answer them. I think the most convenient place to deal with them is likely to be in respect of relief. And you'll have seen in our submissions that we've accepted throughout, this is not a case in which mandatory relief would ever be appropriate. We've sought discretionary relief on the basis that the shape of a reasonable system is a matter for the respondent and will have to take account of a range of factors, including how it fits as part of the larger mosaic referred to. That's also entirely consistent with the approach taken by the Secretary of State for Education in their relatively hands-off submissions, where they said, here's the framework, here's how you assess whether or not the Gateshead duty is met, here's how we assist you with the yardstick, and they also referred to the non-prescriptive nature of their guidance, save that they make clear you must meet, in their guidance, which is statutory guidance, you must meet the Gateshead duty and provide accommodation, and resources isn't a reasonable response. But they then say that precisely how a reasonable system is constructed is a matter for local authorities. So in our view, that's an issue, an important issue, which go to the question of relief. And we also have very much in mind that my learned friend may well make a submission to you that even in the event that you're with us on this being an unreasonable system, it may be suggested to you that you shouldn't exercise your discretion to grant relief despite that. So we're conscious of that.
Yes.
Would that be a convenient time to come to it?
Entirely a matter for you, but since you've raised the question of relief, that does prompt in my mind another question I had intended to ask you when we got to relief. Do we have to bear in mind that we are not the court of first instance? We are the court of appeal, considering an appeal from the divisional court, and our jurisdiction is only available where we consider that the court below is wrong.
Yes.
Now, when it comes to the last of your 4 grounds of appeal, which is about what the court said it would have done in its discretion on matters of relief, but apart from the earlier substantive issues, if we reach the question of what the divisional court said it would have done in its discretion on matters of relief, what I will need your help on, speaking for myself at least, is what basis would there be for this court to interfere with their exercise of discretion? We're not able just to substitute our own view of what we would do, or are we? I mean, you'll have to help us on that.
I think I'll resist the temptation to give you a preview of the response and deal with it. I'm just very conscious, and it's entirely my fault. I've given you a very long introduction. But may I deal with that, my lord, when I come to the question of relief?
Of course.
And it may be, depending on how we're doing for time, I'm just mindful with COVID restrictions, it's a little difficult to turn my back and take instructions quietly. It may be that it's convenient for me to take just 5 minutes to confirm my instructions on the various points. I was intending to start with fresh evidence as a specific point, but as we've discussed, I won't do that. So there are 4 headings which I'll take, and I'll be able to take them relatively shortly, given the length of the introduction and given the fact that the vast majority of the judgment below is in fact not in dispute. So first of all, the statutory framework. I'm going to turn to the statutory framework and just highlight some points about the summary in respect of the statutory framework in the divisional court's judgment is not in dispute with either party. Secondly, I'm going to turn to the system currently in place and the current provision, setting the nationwide context, although in fact we've addressed a little of that in my response to your question, my lord. And then the current provision within the London Borough of Waltham Forest. So that's point 2. A third, applying the yardstick, which is, we say, paragraphs 42 to 48 of the Gateshead judgment. Does the system the London Borough of Waltham Forest have in place meet that yardstick? And our submission is that it does not. And then fourthly, I'll turn to the question of relief.
Right, statutory framework.
Thank you. So, my lady, my lords, the statutory framework is dealt with in some detail in our skeleton argument, paragraph 2.1 to 2.15, which is, you'll see it marked as 3.13 at the top of page 22 of the bundle. and then there's a reference to the underpinning international legal standards. And it's dealt with in the judgment in a manner which is not in dispute. So section 38 of PACE sets out the duties of the custody officer after charge. My lady and my lords, do you need to turn up section 38 to have a look at it? I'm quite happy to do that if that would be of assistance.
I think it may be useful just to have it in front of us.
Yeah, apologies, my lady, I didn't hear.
Yeah, I think it'd be useful for us just
Thank
to have
you.
it in front of us, but it won't take a moment as it's in tab 1.
So you'll see it's behind tab 1. Starts at page 7 of the bundle. The reason you then have section 37, just for context, is that just while you're on this page, if you turn back to page 5, section 37.15, you'll see the definition of arrested juvenile, being a person arrested with or without a warrant who appears to be under the age of 18. And although that's the statutory term of art, our instructing solicitors from Just for Kids Law don't use the term juvenile. You'll be aware of that, so I won't use that term. We will refer to AR and others in this position as children. So section 38 is the duties of the custody officer after charge. So section 38.1 makes clear that the custody officer shall order the person's release from police detention, either on bail or without bail, unless, and then there's two options. Firstly, if the person arrested is not an arrested juvenile, there's the adult provisions. And then you'll see under 38.1b, if he is an arrested juvenile, if any of the requirements of paragraph A are satisfied, or the custody officer has reasonable grounds for believing he ought to be detained in his own interests, and the offence with which the person is charged is murder. So you see that 38.1b, and then there's the reference to C also. So 38.6, which is at the bottom of page 8, is the key provision for our purposes. So this is a situation where the custody officer has formed the view under subsection 1, so that'll be subsection 1b, that in fact bail should be denied to the child. And although bail is denied with an adult, the person would then just remain in police custody. But under section 38.6, when that decision is taken for a child, the trajectory of the decision making is different. So where the custody officer authorises an arrested juvenile to be kept in police detention under subsection 1 above, the custody officer shall, and there's then the subclause which I'll come back to, secure that the arrested juvenile is moved to local authority accommodation. So section 38.6 requires that where bail is refused for a child, the custody officer shall, it's mandatory, secure that the arrested juvenile is moved to local authority accommodation. There's then the subclause, which is the caveat to that, and that is where the custody officer certifies that by reason of such circumstances as are specified in the certificate, it's impracticable for him to do so, or in the case of an arrested juvenile who's attained the age of 12 years, that no secure accommodation is available, and that keeping him in other local authority accommodation would not be adequate to protect the public from serious harm from him.
Ms Gallagher, would you accept or would you regard 6A to be satisfied if the custody sergeant, for the reasons mentioned by my Lord Justice Singh, said, well, this is nonsense, you know, it's now midnight and I need him back here, or I need to have him at the magistrates for 10, so it's simply impractical to look at moving him out.
This is why looking at section 38.6 and section 21 together is so critical, because this is a situation, section 38.6 fixes a duty on the custody sergeant. So the custody sergeant shall secure that the arrested juvenile is moved to local authority accommodation. Now, if you have a situation where, for example, the child is charged an hour and a half before attending court in a local authority where the nearest accommodation, not dealing with secure, the nearest accommodation of any kind is some distance away, there may be a question about whether the local authority is complying with the section 21 duty, but for the custody sergeant, there is an excuse for non-compliance with what would otherwise be a mandatory duty under section 38.6. So we're also quite conscious that under section 38.6a, where you have an impracticability because of non-availability of accommodation, that may mean that the custody sergeant is acting in a way which is compatible with the Section 38 duty, but there's a separate question about whether the local authorities complied with the Section 21 duty.
Perhaps I wasn't being very clear. Of course, it can be impractical because they've made the telephone call and the local authority have said sorry.
Yes.
But what I'm saying is, will the custody sergeant be discharging his duty under 6A or under 6 if they take the very practical approach that it's not practical to try and ship this child out?
So this is the example given. Difficulty with getting a hot dinner the night before, difficulty with getting breakfast, and so on. So I'm conscious that this is quite a separate point to this case, because we don't dispute that the Metropolitan Police Sergeant here made a Section 38(6) compliant decision. But just by way of hypothetical, my lady, could I just give you an indication? Firstly, the statutory scheme, looking at Section 38(6) and Section 21 together, is clear that in cases where you're looking at a child refused bail post-charge, the statutory object and purpose nevertheless is that they should be transferred to local authority accommodation. Now, in a great number of cases, that will involve a short period of time, because the first appearance is going to be 10 a.m. the next day. As my Lord Justice Singh has indicated, that may require attending at court and being in a cell at the court at 8 a.m. or 8:30 and potentially getting a van quite early. And my Lord Justice Singh's questions earlier about whether it could be in a child's best interest for them to be transferred in those circumstances are questions, we say, for the legislature, because Parliament has considered this issue. Parliament has taken the view that a child in this position, under Section 38(6), should be transferred. The custody sergeant shall secure that the arrested juvenile is moved to local authority accommodation. And the examples given of routine difficulties, if they were to satisfy the Section 38(6)A test, it would entirely drive a coach and horses through the Section 38(6) duty in our submission. So although it's a hypothetical, I would say no.
The answer is no.
That's right. I do also have in mind that there's a slight circularity sometimes in how these hypotheticals are put, and it's a particular problem which we'll come to when we're looking at the judgment of the divisional court, in particular, it's paragraph 82. I won't turn it up now, but I will turn to it when we come to it. It's paragraph 82 in Lord Justice Davis's analysis, where there's the reference to, in fact, it's 83, where he says there's a question of how it can be fair to a child to be placed in a car at a police station late at night, driven for a considerable period of time to secure accommodation, then be rousted out again in the early hours to be driven back to court. And of course, that's entirely circular, because at present, you do have to drive for a long period of time. The question is whether having a system which inevitably means that a child is going to be placed in that position, either of there being a no, or there being a 6-hour round trip across the country when there might only be an 8-hour window before you're required at court. There's a question about whether that's reasonable. But in answer to my lady's question, our view is that in the vast majority of circumstances, that will not be a justification for saying it's impracticable, because it would simply undermine the statutory obligation in 38(6).
I have to confess that the sort of concerns that Lord Justice Davis expressed in the passage you have cited have been in my mind as well. And of course, if there's a circularity about them, then you must allay those concerns in due course, not out of order. But the reason why it may be relevant to the thrust of your main submission is that it may be that on your submission, if one were truly to achieve a rational system, you would have to have, frankly, a lot of places and very close to the courts. Because otherwise, even if you have an improvement, and I know you complain about the current arrangements, but in the real world, an improvement which leads in a year's time to your client still being unable to get a secure accommodation place. Because there are a few more places, but there still aren't enough, and they're not close enough to the courts. An improvement is not going to do any good to your client or people like him in the future. So what I'm wondering is what the consequence of our judgment would be. If we accepted the thrust of your submission, are there going to have to be, quite frankly, a lot more places, and they're going to have to be pretty close to courts, because otherwise there's no point. And the police cell may be the least bad option, actually, in reality. And that's what lay behind my question about the best interest of children, which I think is the concern Lord Justice Davis was also expressing. Otherwise, let's suppose Hail Shun is available. In reality, it seems to me, that's going to involve, let's say the charge is at 9 o'clock in the evening. So you are going to have to drive somebody very late. You're going to have to wake them up again very early, because it'll be a couple of hours drive probably, given traffic. And I speak from the experience of having been a trial judge. Lots of times we would be waiting because inevitably the van was stuck on the M25.
So, my lord, I've added that to the list of questions, and I will come to them. Can I just give you some initial, just preliminary thoughts? The reference that was made, as I've taken it down, is that in these cases a police cell may be the least bad option. If the system in place, or lack of system in place, results in a view that a police cell is the least bad option, then I'm afraid that fails the Padfield test. It's just not in keeping with the statutory object and purpose of the legislation. So Parliament has considered this issue. Parliament has formed a view. Section 38(6) and Section 21 are clear that in these circumstances a child should be transferred and there should be a system.
Well, unless by reason of such circumstances are specified in the certificate, which presumably is the certificate the custody sergeant has to complete.
Yes, that's right.
It is impracticable for him to do so, which is why I asked the question.
Yes, but the point is that Section 38(6)(a) and (b) are the exceptions. So when you read the statute, it's clear that the presumption is that the custody officer shall and is mandated to secure the child is transferred.
I understand that.
These are the two exceptions. So if impracticable is interpreted in such a way, that would essentially mean, in almost all cases, keep the child in the police cell, to use your phrase, my lord, the police cell may be the least bad option instead of bundling them into a car and transferring them and so on. It's impossible for us to see how that in fact complies with Section 38(6).
Sorry, I understand that, but I don't see why my lord's observation might not be relevant in many cases.
Yes.
I mean, impractical in the interests of the child. Like, I don't see how you can say, with legislation of this kind, that the custody sergeant simply ignores the interests of the child.
Oh no, and I don't.
Then if it's plainly not in the interest of the child at 10 o'clock at night to travel 3 hours or whatever it is, then it's fair to say so. I understand your point about circular reasoning, but there are always going to be some cases, however close the place is, where it makes no sense to send them. So it doesn't follow from that you aren't going to have quite a number of cases where the problem arises in the afternoon and you could do it, and you could do it essentially, you could do it perfectly properly.
Yes.
But you can't be right, I think, to say that the legislation requires the custody sergeant to do something which plainly everybody would say makes no sense and isn't in the child's best interest.
My lord, my apologies. I must have misspoken. First of all, we are of course clear that the decision that the custody sergeant makes must have regard to the best interests of the child. Indeed, a custody sergeant, as a member of the police force, is obliged to do so under Section 11 of the Children Act 2004, which we've not provided you with in the bundle. And of course, in compliance with their Article 8 obligation, which you read, Neulinger and
I'm sorry if I misunderstood your point, but
No, I'm sorry, my lord, and thank you for the question and allowing me to clarify. Certainly that is not our submission in relation to Section 38(6). Of course, the custody sergeant making the decision needs to have regard to the best interests of the child and needs to look at the specific circumstances of the child. As you'll have seen, when this case was originally issued, it was both on the systemic issue, ground 1, and ground 2 related to the specific decision making in this case, and permission was refused on that point. That's why it comes before you divorced from the facts of what happened to AOR, and you'll have seen the reference to the rather unfortunate, to use Lord Justice Davis's point, the absence of evidence about what happened in this specific case. But in individual cases, there of course will be circumstances in which the presumption in Section 38(6) will be displaced. And that's why it's structured in that way. But it's clear to us in our submission that Section 38(6) has a strong presumption of transfer to local authority accommodation. I'm referring to both secure and non-secure here. But the individual custody officer may certify if something falls into the circumstances set out in 38.6a or indeed section 38.6b. And nothing I said should have suggested otherwise, and my apologies, my lord, for that confusion. And could you just give me a moment? I am going to come in a moment to the fact that Gateshead, of course, makes clear it's not an absolute duty in relation to secure accommodation. And of course, that means that there will be cases, as with the girl in Gateshead, where a court may take a view that, in fact, on this occasion, it cannot be met. And even if, in fact, the London Borough of Waltham Forest did an analysis and found that in any given year there are 50 requests for secure accommodation and therefore made 50 placements available, limited to its own local authority, in a given year you might have 52, and you could have 52 requests on the same evening. And so, of course, there are circumstances in which, in any event, regardless of what system is in place, there will be refusals in individual cases. And that's why the statutory scheme is clear when we come to section 21, that there's an absolute duty in relation to local authorities when it comes to non-secure accommodation, akin to the section 20 duty. For secure accommodation, it's different. And that will result in answers which are no on occasion. And my lord, on your question earlier about how this may help, of course, there may well be a situation where a child in the position of AOR is given a no, and the end result for them is very similar. But the reason for that is not, as we say here, a total absence of a reasonable system in violation of Waltham Forest Gateshead duty, but is a local authority that does in fact have a reasonable system in place, but simply doesn't have an appropriate placement on that particular evening when the particular request is made. I will come in relation to relief to what we in fact do and what the court's options are, but could I turn now to section 21, unless there's anything further I can assist with on section 38.6.
I just have one question,
Of course.
It's a genuine question, because I don't know the answer. What's the significance of the age of 12 years, which is inserted in parentheses in paragraph B? What's to happen if otherwise that provision was satisfied, but somebody's below the age of 12 years?
Yes, so this is section 38, 1B, Roman numeral 1, just for everyone's reference, at the very top of page 8.
Right.
So this is, and it's one of a number of circumstances in which differentiation is made between children of different ages. And the court, of course, will be aware that previously a differentiation was made at 16 for other purposes,
yes.
Which then stopped after the divisional court's judgment and a change in the statute. But this is one of those examples where a distinction is made between children who are aged 10 and 11 or children who are aged 12 and upwards. I don't have all of the references, but can provide them if it would be of assistance for the court. I am conscious of the background to this being that children at the age of criminal responsibility, being very young, primary school pupils, aged 10 and 11, are treated differently to older children, which is not surprising. But that's why the reference is there. So you go back to the presumption in 38.1 that the custody officer shall order the person's release from police detention. And then this is the provision relating to children, and it distinguishes there between 12-year-olds and up and children who are below that age. So there's an even stronger presumption for release of a child who's aged 10 or 11.
Even stronger presumption. But if the presumption doesn't apply, where in the real world, where are they put?
In these circumstances.
If your client had been aged 11,
yes,
and your circumstances were otherwise exactly the same, where would physically he have gone?
Give me a moment. I just want to make sure I'm understanding it, because I can hear
and come back to the. I'm sorry to take you out of order.
No, please don't worry. Please don't worry. And in fact, I know it's sometimes quite unhelpful to come back to the questions later when you don't have it in front of you. So if you just give me a moment, I'll just ensure that I've got the point. Yes, because just before I turn, can I just show you the cross-reference? Because it wasn't directly relevant here, I hadn't taken you to it, and my apologies. So section 38.1 has section A relating to adults, and then section B, very bottom of page 7, if he's an arrested juvenile. Yes. 38.1b, Roman numeral 1, has the cross-reference to the requirements of paragraph A above. So it imports the adult test under A above, and you'll see that that is where the name or address cannot be ascertained, or the custody officer has reasonable grounds for doubting whether a name or address furnished by him as his name or address is the real name or address, reasonable grounds for believing the person arrested will fail to appear in court to answer to bail, or necessary to prevent the person from committing an offence in the case of an imprisonable offence, and then there's the reference to the sample. So they are a basis for refusing bail to an adult, and they're a basis for refusing bail to a child who has attained the minimum age. But they're not basis for refusing bail to a 10 or 11-year-old. That's the first issue. The second issue is, regardless of the age of the child, what we deal with in many of these cases, and Just for Kids Law deal with in many of these cases, or the vast majority of these requests are for non-secure accommodation, where there is an absolute duty. And regrettably, there are, of course, many instances in which that obligation is not met. And there hasn't yet been, because there have been a large number of cases issued on this, but they have all settled. So there isn't a reported judgment on that issue about non-compliance with the non-secure obligation, akin to the Section 20 obligation. I don't want, I'm conscious you asked me for some factual information. I can, of course, give you more information if helpful. It won't surprise you to know that in line with the line of case law that went to the Supreme Court in 2007, 2008 about routine non-compliance with the Section 20 obligation, similarly, there's a wide range of this material. And you may remember casting your minds back some time to your days as urgent application judges, to there being many of these cases involving children who are not accommodated. And there's a particular problem with Section 38 children, whether secure or non-secure, because the applications you make to a duty judge in relation to non-compliance with the Section 20 obligation can be complied with that evening. You often have an order which requires the child to be placed that evening. But here you're dealing with a child in a police station, and often a very, very short period of time. It's part of the reason why these cases quite often simply don't make it to court, and one of the reasons why this case is such an important case for you to be looking at, it seems to us. On the secure accommodation issue, you had a question, my lord, specifically about a 10 or 11-year-old. Now, a 10 or 11-year-old could, for example, fall within the own interest test in 38.1b, Roman numeral 2, just for completeness. I don't think it's relevant, but mindful of my obligation to the court, there is a case before the Court of Appeal currently which has been heard and is awaiting judgment regarding whether the own interest detention of a child provision is Article 5.4 compliant, in which I acted for Just for Kids Law and Liberty as the interveners, and Mr. Richard Harbour, Queen's Counsel, acts for the appellant. That has been heard and judgment is awaited. I don't think anything turns on it, which is why we haven't provided you with the information, but just by way of context. That, of course, could apply to a 10 or 11-year-old, and a 10 or 11-year-old could also fall within the murder provision also.
But in real-world practical terms, does that mean that a 10-year-old, for example, may spend the night at a police station?
Yes,
Right.
and regrettably there are examples of that. In fact, there's an example in some of the material before you from the Howard League of an 8-year-old spending time in a police cell. And some of the statistics which are in the supplementary bundle, I haven't taken you to them. There is evidence of children up and down the country being in police cells in sharp contradistinction to the statutory purpose, and also in sharp contradistinction to the international materials, which, as the Divisional Court accepted, make clear that police custody, no matter how short a period, is not a suitable place for a child, and children should, as required by the UN Convention on the Rights of the Child, Article 37, be detained separately from adults. That doesn't just mean separately in a cell, it means in a separate institution. And that's precisely what lies behind Section 38.6 and the presumption in Section 38.6, not a mandatory, inescapable duty, but a presumption that the custody officer shall secure that the arrested juvenile is moved to local authority accommodation. this is one part of the picture, because this is the obligation on the custody sergeant. And as you know, in this case, there was no dispute relating to the compliance by the Metropolitan Police with its obligations. And indeed, I'm mindful, given some of the practical questions which have been raised, you don't have in your bundle the appropriate adult case from a number of years ago, but one of the issues which arose there was very similar to the questions that are being asked, my lady and my Lord, Lord Justice Singh, related to a custody sergeant in the middle of the night having to make a decision, and the difficulty in a custody sergeant having to comply with their Section 11 Children Act 2004 duty in circumstances where they weren't aided by having a simple system available to them. And there are some parallels with the situation here. But the Section 38(6) duty in this case, there's no dispute that that was met. The custody sergeant makes the request for secure accommodation, and then because Waltham Forest cannot comply, the custody officer quite properly certifies that it falls within Section 38(6)(b). No secure accommodation is available. It's a case where secure accommodation was required, and you've seen the background as to why that's a decision which is not under challenge. So what you then need to look at is the other part of the jigsaw, which is the Section 21
Before we
provision.
leave 38,
Of course.
I'm sorry, can I
No, don't worry.
delay you with
I
one more
spoke too
question?
soon,
I'll
saying I
complain
was
later
going to be
that you-
short.
I'll
My
complain later that
apologies.
you've taken too long, but I'll ask you another question. In relation to 38, 6A and B, I just wonder, I suppose you wouldn't know the answer to this, but I wonder how often the custody sergeant may say to himself or herself, there's no point in trying to get hold of the local authority because there simply isn't any space. History tells us we're going to get an answer no. And so will bring himself or herself under A. It's not practicable. But I suppose you simply have no way of knowing.
Well, I've pleaded many civil claims on that basis. It is right that you sometimes have situations where local authorities, they're in an area where a local authority will inevitably say no. And there have been some instances, and I'm afraid this will have to be anecdotal, but given that the question's been raised, there have been instances where some police forces simply stop making the request. Now, one of the reasons why the Concordat has been brought in, which you also have in the bundle, I believe, let me just confirm that it's in there. We in fact didn't put the Concordat in. It is in there. It's in the evidence rather than the authorities bundle. I'll get the reference in a moment. One of the reasons that the Concordat is in is because of a range of evidence suggesting there were widespread problems with compliance with this obligation, primarily on the part of local authorities. But there were some difficulties with police forces, including police forces not making the telephone call, which would result in the inevitable no, and simply recording, for example, it's impracticable. Now, one of the difficulties with that, of course, is that the Section 38(6) presumption of a transfer to local authority accommodation is then undermined entirely, simply because the local authority doesn't have, in compliance with its gateshead duty, a reasonable system for secure accommodation. And I regret to say, my lord, on many occasions, local authorities do not have accommodation to comply with their absolute Section 21 duty in relation to non-secure accommodation. And there are instances of calls not being made there too. I'll pull up the references a little later, but the Concordat does make reference to that widespread evidence about non-compliance, and which may be helpful in light of your question. Could I ask you to turn to Section 21, which is in tab 2? And I'm sorry I'm making slow progress, but I hope
I don't think it's your fault.
Or Justice Singh's fault.
That's right.
I'm on question 27, my lord. I hope I've got an accurate note. But, and I will ensure that I answer all of these. And if there's anything I cannot answer in detail immediately, I'll ensure that we, of course, provide you with any further detail in writing. Just before I move off Section 38(6), may I just check one thing? And I should say, I am, of course, going to come to the gateshead duty and what Section 38(6) means, but I wanted to first take you to Section 21. Could you just give me a moment? Thank you. So Section 21 starts, it's tab 2, page 14. In the authorities bundle. And this, of course, is part of the section of the Children Act 1989, which places various duties and obligations on local authority children's services departments. And you'll have seen in the Gateshead judgment the analysis of how Section 21 relates to Section 20 and how similar it is to the Section 20 duty for non-secure accommodation and how Section 21 relates to Section 25. The key issue is that under Section 21(2)(b), you can see that every local authority shall receive and provide accommodation for children whom they are requested to receive under Section 38(6) of the Police and Criminal Evidence Act. Now, that is a section which applies to both secure and non-secure accommodation under Section 38(6), contrary to the submission rejected by the local authority in the Gateshead case, which was essentially secure accommodation is entirely out with Section 21. So it is correct. Court of Appeal accepted it in Gateshead, and we agree that Section 21(2)(b) applies to both categories of Section 38 accommodation. It also would ask you to also look at children in police protection, Section 21(2)(a), who local authorities are requested to receive under a different provision, Section 46. And children remanded to local authority accommodation by the criminal courts, which you see in Section 21(2)(c). And just for completeness, and it's recorded in the Divisional Court's judgment and not in contention, a child who's provided with accommodation by the local authority for a period in excess of 24 hours is looked after by a local authority for the purposes of the 1989 Act. That's Section 22(1). And then, depending on the amount of time accumulated as a looked after child, they may acquire leaving care duties. So many of the Section 38(6) children will not, in fact, end up being looked after during that period, the statutory definition. In fact, AR was already a looked after child, so it's a different situation. So Section 21(2)(b) is the key provision for our purposes. And that's an interlocking provision. So Section 38(6) is the duty on the custody sergeant. Section 21(2) is the duty on the local authority receiving the call from the custody sergeant, making the request for either secure or non-secure accommodation. Now, Section 53 of the Act, we've also included. Section 53, you'll find at page 29 of the bundle. And this is the provision of community homes by local authorities. I should say before turning to this that, of course, with non-secure accommodation, a local authority may discharge its Section 21 duty in the same way it discharges its Section 20 duty in a range of ways, including by placing the person in supported accommodation. It depends on the circumstances. But when it comes to secure accommodation, the local authority is more constrained. And that's why you have this distinction between mandatory duty akin to the Section 20 duty for non-secure accommodation, but a discretionary power to be exercised by the local authority in relation to secure accommodation. So Section 53 is an important part of this jigsaw because it provides that every local authority shall make such arrangements as they consider appropriate for securing that homes, community homes, are available for the care and accommodation of children looked after by them and for purposes connected with the welfare of children, whether or not looked after by them, and may do so jointly with one or more other local authorities. So that's Section 53(1) on page 29. And then you'll see 53(2). In making such arrangements, a local authority shall have regard to the need for ensuring the availability of accommodation, A, of different descriptions, and B, which is suitable for different purposes and the requirements of different descriptions of children. So were a local authority, for example, to take a view, just hypothetical local authority, that they would make provision for ensuring only the availability of accommodation which is non-secure, there is then a question as to whether they're complying with the requirement in Section 53(2) to have regard to the need for ensuring the availability of accommodation of different descriptions and which is suitable for different purposes and the requirements of different descriptions of children. So that's an important part of the jigsaw when you're looking at how it fits together.
How does that work? I mean, let's let's assume there are, say, 4 requests a year for
Yes.
a particular local authority. Could they say, well, we're simply not going to provide accommodation, secure accommodation, because having regard to the need for ensuring the availability of accommodation of different kinds, we come to the view that it simply makes no sense financially, and that we've got other obligations, and they really must trump this one. Can they do that?
So, first of all, that's of course not this case here. So that's a much more nuanced and more difficult case than the case we have here, where we say the London Borough of Waltham Forest has a number of these requests, has simply failed to comply, doesn't have a reasonable system. And that particular example, were it the case that you had to provide it only within your own border, it would be more powerful. But in circumstances where Section 53 recognises that homes can be provided by local authorities jointly with one or more other local authorities, it seems to us that an approach like that would not be reasonable. And again, coming back to the Padfield test, how could a decision that a particular category of child should never receive accommodation when it's requested, how could that possibly be compatible with the object and purpose of the statute? Now, the test, as described in Gateshead, is that the object and purpose of the statute is to ensure that children are not detained in police cells where possible. So there's a last resort option of children being detained in police cells. But a local authority taking the view, this is only a small number of children, we're making no provision for them, seems to us that that would be the local authority fettering its discretion in a way which is unreasonable and not in compliance with its obligations.
Sorry, I understand that, but I wonder how 53.2 fits into that. I mean, one might have thought that it would say you have an obligation, not just have regard to the need, but you have an obligation to make available accommodation of different descriptions.
Well, this is where Section 53, it's helpful, it's just because it came later in time, we've put Section 22G in the bundle as well. So Section 22G is at page 24 of the bundle.
Yeah.
So it's in the same tab, my lord. And that's rather like the homelessness avoidance legislation. That's a general duty described by Ms. Justice Andrews as a aspirational duty to secure sufficient accommodation for looked after children. And you'll see there's a reference 22G1. It's the general duty of a local authority to take steps that secure, so far as reasonably practicable, the outcome in subsection 2. And then the outcome is described in 22G2. The outcome is that the local authority are able to provide the children mentioned in subsection 3 with accommodation that A, is within the authority's area, and B, meets the needs of those children. And then you'll see in 22G3, the children referred to in that subsection are those that the local authority are looking after, which includes AR, or in respect of whom the authority are unable to make arrangements under section 22C2. And you have that a little further back, it's not directly relevant here, and whose circumstances are such that it would be consistent with their welfare for them to be provided with accommodation that is in the authority's area. And then there's a requirement under 22G4 that in taking steps to secure that outcome, the local authority must have regard to the benefit of having a number of accommodation providers in their area sufficient to secure the outcome and a range of accommodation capable of meeting different needs. Now, you'll have seen from the High Court judgment that there was a specific argument advanced about section 22G about the proactive obligation to gather information and inform yourself, essentially a Tameside type obligation under section 22G. You'll have seen that Mrs. Justice Andrews was not impressed with that argument. But in fact, nothing turns on this. The reason section 22G is relevant for present purposes is it's simply part of the overall jigsaw, and it wasn't before the court in Gateshead, of course, and it reinforces the point that there is the statutory objects and purpose of section 38(6) PACE and section 21(2) of the 1989 Act. The statutory purpose of that scheme is to minimise the risk of a child being in a police cell overnight, even post-charge for that short period of time. And then section 22G and section 53 just underpin that and show that consideration has been given to the obligations on local authorities to meet that need. The statutory guidance, which we have in the bundle also, volume 2, I won't turn this up, but may I just give you the cross-reference. It's a paragraph 2.8 of our skeleton, and it's a tab 14 of the authorities, just for time. I won't turn it up unless you'd be aided by that. But that refers to section 22G, requiring that local authorities show they're taking steps at strategic level to secure accommodation so far as reasonably practicable. And it says expressly, local authorities should not assume, for instance, that it is not reasonably practicable to secure appropriate accommodation because it's difficult to do so or because there's a lack of resources. And that's important, of course, because volume 2, care planning, placement and care review is statutory guidance in line with the RICSN requirements. The local authority has an obligation to have regard to it in making its decisions. The final part of the jigsaw when looking at the statutory scheme, well, there's 2 points. The first is that the local authority that when accommodation is not provided under section 21, there is a duty on the local authority to reimburse police the reasonable expenses of accommodating the child. I'll just get you the page reference for that. I've just, you can see I've got a tab which has come loose rather unhelpfully. It's decorating decorating the wood here and not decorating the page. I'll get you the reference. So that's the first key point, that the statute recognises if the custody sergeant has made the call and is in a position where it falls within section 38(6), either A or B, the provisions that my lady was referring to earlier. When accommodation is not provided, the local authority must reimburse police the reasonable expenses of accommodating the child. So it's another part of the jigsaw showing the presumption is a child in that position should in fact be accommodated by the local authority, not in a police cell. And the second point, which is the final part of the statutory jigsaw, is section 82(2) of the 1989 Act. And it's again in tab 2. I don't ask you to turn it up just for time reasons. And that provides that the Secretary of State may make grants to local authorities in respect of expenditure incurred by them in providing secure accommodation in community homes other than assisted community homes. And the reason that's important is that when you then turn to the judgment and you have the reference of paragraph 72, accepting my learned friend's submission that this is a problem on the part of central government, you have the court accepting, paragraph 72, that this claim is really a complaint about the nationwide lack of secure accommodation available to all local authorities due to the absence of funding by central government. And in our submission, that is simply not borne out by the evidence and was the divisional court falling into error. There's no evidence whatsoever before you of Waltham Forest, alone or jointly with others, making a request for funding under section 82(2). And of course, if there was a request made under section 82(2) and it was refused, you may be having a judicial review appeal in front of you concerning whether that's a judicially reviewable decision. And of course, you'll be aware of many other contexts where local authorities are in fact challenging decisions by central government in respect to funding. But there was a very general, non-evidence-based submission made. This is all a problem for central government. And you'll have seen from the papers before you that we, Just for Kids, Secretary of State for Education, Unlikely Alliance, and with the Metropolitan Police also, we're in fact on precisely the same page in respect of this issue, that there is a fundamental problem, that there is an availability under section 82(2) for funding to be sought from central government, and there's no evidence whatsoever in any of the bundles before you of such an application ever having been made. I'll come in due course to the 2019 options paper, which is the only evidence of any step having been taken, which we say doesn't even go to this issue at all and relates to other types of secure accommodation.
Ms. Gallagher, can I ask another brief question?
Of course.
I hope it's very brief. Section 53 talks about provision of community homes. The other provisions we've talked about deal about provision of accommodation. Is there any material difference between that, or is it the same thing?
So community homes is a subset. So accommodation is general. So accommodation could include, for example, although it shouldn't for children. It could include B&B accommodation. It could include being temporarily placed in a hotel. It could include being placed in a foster placement, in a Section 20 placement, a voluntary placement with a family friend. There are various types of accommodation which can be provided, or indeed, as the duty judges often have to order, accommodation provided by a private provider, which may be semi-supported, for example. But community homes is different, because community homes is about a specific institution.
So Section 53 is much narrower.
Yes, it is. It's a subset.
Okay.
And with that rather long preamble, may I take you to, in our skeleton, I'm not going to turn this up because it's not controversial, it's accepted. Could I just ask you to note, we have summarised in paragraph 2.15 to 2.20 of our skeleton the parliamentary intent of keeping children out of police custody being consistent with international legal standards. Before turning to Gateshead, just want to give you those references. I'm afraid some of you will have been subjected to my lengthy submissions on the UNCRC previously, and I'm not doing that today, it's not controversial. Article 37B of the UNCRC provides that the detention or imprisonment of a child shall be used as a measure of last resort for the shortest appropriate period of time. That's in the bundle. There's also a similar requirement set in the UN standard minimum rules for the administration of juvenile justice, the Beijing rules, detention pending trial being used only as a matter of last resort, shortest possible period of time. And we've given you also the reference to the Council of Europe guidelines. They're the child-friendly justice guidelines. And they all sing from the same hymn sheet. And we say they also sing from the same hymn sheet as the statutory scheme here. Just for completeness, we've given you one of the relevant cases. We've given you ZH Tanzania as one of the very many cases before the Supreme Court over the past 10 years on the centrality of the UNCRC to determining issues concerning children. I'm very conscious my Lord Justice Elias has, of course, sat in a number of those welfare cases relating to those provisions. We haven't given you SG, the range of authorities. It's an uncontroversial principle, and we've summarised it, we hope, succinctly in those 2 pages of the skeleton. So against that backdrop, could we now turn to the Gateshead case? So that is tab 8 of the authorities bundle. Now, in this case, you are dealing with a child who's a girl, and in Lord Justice Dyson's judgment, you'll see at paragraph 3, page 95, that she's charged with an offence of wounding with intent, 2340 hours, and there's then a telephone call at 20 minutes past midnight, when, in the course of the conversation, the police sergeant inquires whether the council can provide secure accommodation until the child is produced before Sunderland magistrates at 10 a.m. later that morning. And you'll see at paragraph 6, and paragraph 5, she's detained overnight at the police station because there's no secure accommodation available. And then paragraph 6 onwards, there's the explanation of the trajectory of the case and what's happened. I mention that because it may be relevant as factual background when you come to looking at how similar or dissimilar this case is from the Gateshead case. There's then analysis in paragraph 31 onwards, rejecting the local authority's argument that Section 21 was nothing to do with secure accommodation. Secure accommodation is only dealt with in Section 25 was the submission, and that's rejected. Now, Section 25 of the Children Act 1989 does deal with secure accommodation, but Lord Justice Dyson explains in these paragraphs how that interacts with Section 21. Could we ask you in due course to turn to paragraph 35 and read, I'm sure you've read it already, but paragraph 35 to 40 describes what the obligation is and how Section 21 links to Section 25. Because, as Lord Justice Dyson says, and we agree, the purpose of Section 25 is not to create a separate duty in relation to the provision of secure accommodation. It's to restrict the manner in which a local authority may discharge its duty to provide secure accommodation. And the key passages can be found paragraph 41 onwards. And in fact, I see, my lady, it may be helpful for you a little earlier on that page 663, paragraph 40, starting at C. Just in light of a question which you'd asked, and indeed my Lord Justice Elias also asked, do you see that part which says the section expressly contemplates that the custody officer may not be able to secure accommodation that is secure? And that's when I said, my Lord Justice Elias, that I had misspoken if I'd given the impression otherwise. We recognise that it's an absolute duty to provide non-secure accommodation, akin to the Section 20 duty. For secure accommodation, it's a discretionary power, and it's recognised expressly in Section 38(6)(b) that the custody officer may not be able to secure accommodation that's secure. And Lord Justice Dyson explains why that's not surprising, taking account of limited resources and so on. You then come on to what the duty is. And paragraph 41 is the meat of it, which describes the gateshead's duty. So he says the absolute duty is to provide accommodation. This corresponds with the custody officer's duty under Section 38(6) to secure accommodation, not accommodation that is secure. Rather a tongue twister. That is not to say when it receives a request for secure accommodation under Section 38(6), a local authority may simply ignore it. In my judgment, when performing its duty under Section 21(2)(b), the local authority has a discretionary power to provide secure accommodation where that is requested. It's trite law that discretionary statutory powers must be exercised to promote the policy and objects of the statute. See Padfield. The broad policy and objects of Part 3 of the 1989 Act are that local authorities should provide support for children and families. More particularly, the object of Section 21(2)(b), when read with Section 38(6), is, as Lord Justice Watkins said in that Cambridgeshire case as long ago as 1991, that children should not be detained in police cells if that is at all possible. And reference is made to a compelling statement from NACRO 16 years ago, statement from 2005, but the principle holds true. In order to ensure that due regard is given to the safeguarding and welfare of such young people, it's imperative that they should spend as little time in police custody as the proper process of the criminal case allows. In particular, it's always preferable that a young person should not, other than in exceptional circumstances, be held at a police station overnight. And against that backdrop, the court says at paragraph 43, in my judgment, therefore, it's incumbent on all local authorities to have in place a reasonable system to enable them to respond to requests under Section 38(6) for secure accommodation. And that's the sentence I referred to in opening when I said our submission is that having a reasonable system to enable you to respond to requests is not just being a telephone receptionist and answering the telephone and saying no. That's not a reasonable system for responding to requests. That's a reasonable system for answering the phone and saying no. And a reasonable system to respond to requests has a substantive element. Now, it's not an absolute duty to provide secure accommodation whenever requested by a custody officer, and that's clear from the statute, and Lord Justice Dyson agrees. He refers to some of the relevant factors which have come up in questions. You'll see the urgency with which the requests will usually have to be dealt with, comparative rarity of such requests, the resource implications of maintaining a stock. It would be manifestly unreasonable to impose a mandatory absolute duty on local authorities. And in contrast to the rather optimistic argument which was made by the appellant in that case, was saying it's an absolute duty for secure accommodation also, that's rejected. Instead, it's this reasonable system test, and that's the Gateshead duty. And may I also ask you to look at paragraph 48. And this reflects the fact that the statute recognises that the answer may sometimes be no. And you'll see down at F, it's a matter for the judgment of the local authority, taking full account of the need to avoid having children detained in police cells if at all possible, to decide what arrangements to make to provide secure accommodation when it's requested by the police. And my Lord Justice Elias, I have in mind that sentence in response to your question earlier about the hypothetical local authority with only getting 4 requests a year. Why can't they say we're putting our money elsewhere, we're not making provision? In our submission, that would not be a system which takes full account of the need to avoid having children in police cells if at all possible, because it would be a system which has an inevitable negative outcome for any secure accommodation request under section 38(6). And in reality, although that was a question about a hypothetical local authority, that's what we have here, and we'll come to it in a moment. Now, there is some discussion in the divisional court judgment about a comparison with the Gateshead case, and I'm going to come back a little later to why that's problematic. May I just indicate that when you see the end of paragraph 48, there's a yardstick set, which is also the one referred to by Lord Justice Noogie in the permission to appeal decision. So he recognises that this is an area, right? He says this is an area where the court should be slow to strike down as unlawful arrangements that have been made by local authorities, bearing in mind that range of factors. And he says, in my view, they should do so only if satisfied that an authority has made no arrangements at all, so that they can never provide secure accommodation when it's requested, or where the arrangements that have been made are ones that could not have been made by a reasonable authority, mindful of the need to avoid having children detained in police cells, if at all possible. Now, there has been some discussion in academic papers and so on about whether that yardstick is set too high, but you don't need to concern yourselves with that here, because we meet that yardstick anyway. Our submission is that we are precisely in the territory of the London Borough of Waltham Forest having made no arrangements at all, so that they can never provide secure accommodation when it's requested, or to the extent that any arrangements have been made, they're ones that could not have been made by a reasonable authority, mindful of the need to avoid having children detained in police cells if at all possible. So our submission is that when you apply that yardstick, the system, to the extent there is one in place, here fails. And I'll come back to why that is in a moment.
I must say, for myself, I find the first part of that rather a difficult concept. I'm not sure what administrative law principle it is.
Yes.
It says that only if you've made no arrangements at all can it be said that you failed in your duty. It's almost always the second test. Yes. Is it an arrangement which a reasonable authority could or could not make?
And my lord, we agree. And you may have seen, it did take some time in the divisional court, but of course in the divisional court they were bound by the Court of Appeal in any event. So our view is that in fact the end of paragraph 48 does set the bar too high. But although the bar is set exceptionally high by the end of paragraph 48, in the extreme circumstances of this case, we say we fall within it in any event. If you were minded to address the question, and because of course this is a prior Court of Appeal authority on this issue, that first clause in paragraph 48 does indeed sound surprising. So if you look, for example, at Anne-Marie Bullivant's statistics across London for the last year for which statistics are available, 2018, the figure is 342 requests for secure accommodation in 2018 across London, of which one was met. Now, one of 342 is, having my rudimentary maths, having done the calculation, at 0.29%.
I'm sympathetic to that, but one has to translate it into the particular defendant.
Yes, and that wasn't, in fact, a Waltham Forest defendant. That wasn't a Waltham Forest case. So that's a different case in London. The point is, if you have numbers like that in a local authority, where you have, say, a hypothetical local authority, where you have arrangements where they can meet 1 out of every 200 requests, there's of course a question as to whether that's a reasonable system or not. And there's a question about whether the bar is set too high by that sentence in paragraph 48. The reason we had sidestepped that here is because we say even applying that exceptionally high test in paragraph 48 of Gateshead, and we say we fall within it in any event. So the position in Waltham Forest is that they can never provide secure accommodation under section 38(6). There's no evidence that they've ever been able to do so, but in any event, the arrangements are such that could not have been made by a reasonable authority mindful of the statutory purpose the need to avoid having children detained in police cells, if at all possible. Just before I turn to the system, we have also included, let me just check, I just want to give you the reference rather than turning it up. So we've also given you, in the authorities bundle, one of the 3 cases we've provided. We've given you the Smith and Smith case, and that's also related to the statutory purpose point. We didn't give you Padfield. We assumed that would be unnecessary. But the reason we've provided Smith is because, in particular, of what Lady Hale says at paragraph 78, and that is about legislation having to be construed so far as possible so as to comply with the international obligations which the UK has undertaken. And that's why we've included that. I say that just for completeness. Although, as we say, paragraph 4.2 of our skeleton, 4.2d for your reference, and footnote 11. In truth, without even turning to the UNCRC Article 37b, Council of Europe Guidelines on Child-Friendly Justice, the parliamentary intention anyway couldn't be clearer from the face of the statutory provisions and from that paragraph in the statutory guidance that I took you to earlier. So turning then to the system itself.
We have set out at 25 onwards in the judgment.
Yes, that's right. So in relation to that, we've also dealt with it, my lady, at paragraphs 3.11 to 3.13 of the skeleton. I did just want to give you a few references. I'll do it as quickly as possible. I had intended to take about 20 minutes on this, but I can see it's not necessary and I'm anticipating be actively discouraged. So just by way of giving you the context, we did want to draw to your attention a small number of pieces of material. I won't turn them up, but may I give you the references? First of all, there's paragraphs 4 to 6 of that new case that we've given you at tab 16, which refers to the general context. Secondly, there's the Secretary of State for Education submissions below, which in our submission are very helpful. You find those towards the back of the supplementary bundle. Don't ask you to turn them up, but I'm just ensuring I'm giving you the correct page reference. And they start, it's tab C9, start at page 432. And they're quite short. They don't deal with the particular circumstances here. So it's the penultimate tab. And in fact, I can see, I think 2 of you have turned it up. So I'll just give you a reference if you do have it open. You'll see helpful description in paragraphs 12 to 18 of the role of the Secretary of State. And you'll see that's in stark contrast to what's said at paragraph 72 of the judgment by Mr. Justice Andrews, saying this is a central government problem. This is due to the absence of funding by central government. So you'll see it's explained here that the statutory function of the Secretary of State is the approval of secure children's homes under section 25 of the 1989 Act, which you also have in tab 2 of the authorities bundle, and reference is made to the currently approved list of secure children's homes, which has not changed since. 15 of them, they're the units referred to earlier, all run by local authorities, save for one, St. Catherine's, run by a charitable organisation. So 14 local authorities across the country have, in fact, provided secure children's homes, which have now been approved by the Secretary of State. Waltham Forest and indeed all London authorities are not any of them. And there's then a reference to the Secretary of State's approach and how the Department for Education funds a unit that facilitates the referral process between placing authorities and secure children's homes. Reference is made at paragraph 14 to the section 82 power to provide financial support.
Whether they've ever actually made one.
Apologies?
Without telling us whether they've ever actually made a grant.
Yes. Well, that's about the referral process in individual cases. So that's the SAN referred to in the judgment of paragraph 13. Oh, apologies, I understand. Paragraph 14.
You took us to paragraph
Yes.
14, which
I'm so sorry, I
section
misunderstood.
82.
That's right. It's never been suggested that there has been a Section 82 application made.
No. I'm looking at the Secretary of State's statement, and I'm just interested to see that the way it's drafted, A, is it gives a whole lot of reasons at 15, which might be thought of somewhat naive given the general provision of secure accommodation in this country, and at paragraph 14 it tells us that there is the power under Section 82, but it doesn't tell us how often such a capital grant has been made and how many of the 15 units have been funded following the application.
No, it's a rather unsatisfactory feature of this case that despite the efforts that were made at an early stage by both the claimant, now the appellant, and indeed by the judge granting permission and directing that there should be additional interested persons engaged, that actually the evidential picture you have before you is quite patchy. And the evidential picture that was before the divisional court was quite patchy, but certainly our submission is that the evidential picture just does not justify the findings which are made at paragraph 72 to 78 of the judgment. I'll come to that in a moment. There is a reference made by the Secretary of State recognising since 2015, 6 years ago, that there's a fundamental difficulty with complying with section 38(6) of PACE, and that is contained in the supplementary bundle. Could I ask you to turn that up? So you find that it's tab A23, page 169 of the bundle, and it's an important document because reinforcing the position we were discussing earlier in relation to the statute, this is a joint letter from the Secretary of State for Education and the Secretary of State, the Home Secretary, then Theresa May, writing to all local authorities in England 6 years ago, writing to all lead members for children's services. You'll see the heading is Transfer of Children from Police Custody to Local Authority Accommodation under Section 38(6) PACE. We're writing to draw your attention to the serious problems there are in some areas across England in complying with the PACE and the related requirement in Section 21 of the 1989 Act with respect to the care of children who've been charged with an offence and have been denied bail. Section 38(6) of PACE requires that when a child or young person is detained after charge, the custody officer must seek to transfer them to local authority accommodation pending appearance at court. And then reference is made to the two exemptions to that requirement, whereby the custody officer must certify either it's impracticable to transfer them or there's the reference in relation to secure accommodation. And it's then spelt out, we say correctly, in line with Gateshead, just reading the statute, that akin to Section 20, when there's a request for accommodation, there is an absolute duty to comply with it when it's a non-secure accommodation request. Reference is also made there to Section 21(2)(b). Evidence suggests that the legal requirements are not being followed, and reference is made to a number of factors that prevent the law from functioning as intended. And you'll see the final sentence of that paragraph. The law is clear that there are very limited circumstances to justify the detention of children at police stations. And then echoing the NACRO quote from 2005, in the Gateshead judgment, you have two Secretaries of State saying police custody can be a distressing experience. This is particularly so for children and young people in trouble. It's for this reason that the legislation is designed to keep their stay in police custody to a minimum. So that the law is operating as Parliament intended, the government will therefore be working with chief constables, police and crime commissioners and local authorities to ensure that the best interests of children and young persons are served. And what this means is ensuring compliance with the law across all police and local authority areas in England. We've begun to examine this issue comprehensively, and then goes on to make cross-reference to Section 11 of the Children Act 2004, which I referred to earlier, my Lord, in answering a question from you. Now, it seems to us, using the phrase my Lord Justice Singh used earlier about the police cell being a least bad option, if you're in a position where a police cell is routinely the least bad option, that will not be in keeping with that statutory scheme that we've looked at. it won't be in keeping with the international standards, and it won't be in keeping with this view expressed very clearly from the two Secretaries of State. There may be some individual instances where a police cell may be the least bad option and you fall into the impracticable situation. But that's very different to the more general questions about arriving transferred from a police cell to different accommodation where you may not get a hot meal and so on. The fact is that they are matters which Parliament has considered. The statutory scheme is clear. Two Secretaries of State sent that very powerful letter 6 years ago, but the national position has remained dire, to use the term that's used by the Court of Appeal in that case that we've provided to you behind tab 16. So when we then turn to the particular difficulties with this subset of children who require secure accommodation, the picture is particularly poor. Now, I know that you've had the opportunity to look through this, and so, bearing in mind time, I'll tell you the key items that we rely on. You'll see there's a witness statement from Alex Temple from Just for Kids Law. It's a tab A20 of the supplementary bundle, starting at page 155, running to page 160. So that, along with the joint letter from the Home Secretary, Secretary of State for Education, is an important document. The statement of Police Sergeant Anne-Marie Bullivant is important, which you find at pages 422 to 425. It's tab C6. And the respondent's evidence can be found at tab B1, starting at page 206 to 213. And that's Amanda Gordon's description of the system in place. And in essence, she describes, we say euphemistically, that the respondent has procedures in place for dealing with requests for secure accommodation. But essentially, the way we've put it in our skeleton, which we say is right on the evidence, is that insofar as requests for secure accommodation are dealt with by having a system for declining them, Ms. Gordon is correct. What they have is a system for manning the phones and giving an answer. That answer is inevitably no. There is zero evidence in any of the material before you of Waltham Forest ever being able to comply with a section 38.6 secure accommodation request. And she does describe some examples of scenarios in which secure accommodation was accessed. You'll see that in her statement of paragraphs 10 to 13. But critically, they do not relate to a section 38.6 request. And you'll have seen we'd raised a question about Child N. There's no suggestion that that was a secure accommodation request. Now, the new material, which we received at the end of last week, I may just take that now just for ease and just quickly. So you'll of course have seen the application just states the authority wishes to file it. It won't surprise you to know that my solicitors are concerned as to whether the test is met or not. I won't make submissions on that. We're conscious that you'll look at that matter yourself. The statement itself addresses two matters. First, the number of requests met. Now, it refers to a figure of 54% of requests for secure accommodation being met. But that is of little relevance because that relates to all kinds of secure accommodation, presumably primarily refers to welfare beds. The only statistic contained within it about secure accommodation is the reference at paragraph 6 of the statement to, in March and April of this year, 46 requests for secure accommodation being made from London custody suites. 0 were met. That's one every 1.5 days or so. Every day and a half when a request has been made in that 2-month period, the answer is no, 0 of 46. And that fits also with the more general evidence in relation to 2018 from the Metropolitan Police, 342 requests across London. In 2018, 1 met of 342, not in Waltham Forest. So it doesn't appear to us to add anything except to confirm the position hasn't changed. So it's no better than it was in 2018. Second, this statement purports to then address the steps being taken by Waltham Forest to address the shortage. So it says Waltham Forest has contributed to a draft proposal for secure provision in the London region. When we read the statement at the start of this week, it looked to us impliedly as if that had followed the November 2020 spending review. The timing was so short that it was very difficult, obviously, for us to ascertain the accuracy of it. You now see from the Secretary of State's letter that this may be a reference to a draft options paper put forward in 2019. And may I just take you to that document, the 2019 document. That is in the supplemental bundle. I'm so sorry, could you just give me a moment? It's towards the end of the bundle. I'm afraid I've had a tab malfunction and it's just come out. I'm so sorry, I'll come back to that in a moment. Just while I'm getting that reference, apologies for taking you out of order. The statement then refers this is what happens when you rather inelegantly carry your own papers instead of them being carried by a clerk neatly in a box. I'm afraid just some of my tabs have just come out. I'm so sorry. It's towards the very back of the supplementary bundle. It's tab C4, and it's at page 414 onwards. And you'll see it's a report by Clive Grimshaw, dated 18th of June 2019. So, just by way of an indication of what this document in fact is, this is not a Section 82 request, this is not an application. This is a report summarising the background to work undertaken by the Association of London Directors of Children's Services 2 years ago, along with NHS England, to review the use of secure children's homes for London's children. You'll see at paragraph 1, it refers to there being 3 different types of secure accommodation need. Broadly.
I don't think I'm in the right document.
So it's supplementary bundle. It starts at page 414. It looks like this, my lady, with the London Council's.
No, there's 2 documents in that section.
Yes, I'm sorry. It does actually start with a document report by Martin Pratt.
I have it now, thank you.
So it starts at secure children's homes, item 4. Do
Yep.
you have that? And my lords, do you have the document? So the summary I referred to, my lady, is the summary on page 414. It's then the recommendation, the executive being asked to note the work of the steering group and to comment on the proposal being developed. This is an options paper, and I'll show you why there are serious concerns about this, any reliance being placed on this document. So paragraph 1 refers to the 3 different categories, very broadly, of need for secure children's homes. Welfare placements, those placed by a local authority under section 25. Those sent to a secure children's home on sentence if they're refused bail and remanded to local authority accommodation with secure conditions, justice placements. And then the section 38.6 point, young people held in police custody between being charged and appearing in court because they satisfy the serious harm criterion, but no local authority secure accommodation is available. So the justice placements is distinct, the welfare placements are distinct. We're in that third category described there. In due course, if you look through this, we ask you to read it in full, but the key bit starts at paragraph 8, page 418, under the heading Options Appraisal. So the analysis and engagement provided evidence of a need for London to find a better approach to supporting some of the capital's most vulnerable children and young people. And then it describes the review developing a set of options. And if you look at paragraph 9, you'll see what the steering group recommends. There's 4 bullet points. This is the recommendation. It says the steering group has recommended that London commissions the design and build of 2 12-bedded secure children's homes within or close to London in separate geographical locations to be allocated for welfare placements. Second bullet point refers to justice placements, designs each secure children's home to allow for an additional 6 beds each to be added to accommodate justice placements, subject to gaining in principle agreement from the Ministry of Justice. Third bullet point, additionally commissions 2 step-down units of 6 places, each linked to each secure children's home to support children and young people transitioning out of secure accommodation. And then finally, undertakes further work to scope the requirements for provision to support the Edge of Secure cohort and determine the number of beds required.
Section 38.6.
Precisely. And indeed, that was accepted by my learned friend below. And you'll see that recorded in the judgment. It's at the bottom of page 62 for reference, end of page, paragraph 64. A reference is made to tackling the issue collectively. This is what London boroughs were trying to do, although Mr. Underwood accepted that the London Council's initiative had focused thus far upon the provision of accommodation in London that would meet the need for more welfare and youth justice replacements, and did not specifically address places that would be available to respond to Section 38.6 PACE requests. And we and the Secretary of State for apologies.
I'm not sure this is a very telling or fair point, is it? I mean, if the evidence was somewhere, and I can't remember where, that if you have these secure accommodations, then often they're 80% filled or 85% filled. I can quite see why, if one's talking about it in general terms, you focus on welfare and on court referrals, because that's really what you mainly want these for. It doesn't mean that they're not going to be available for PACE. I mean, it seems to me a very narrow criticism to say they haven't in terms said...
That's not correct, my lord. That's not correct. Right. If they're not authorised as Section 38.6 placements, they cannot be used. So that's not correct. The statement of purpose of the Secure Children's Home restricts the use which can be put to it. This is precisely the point which arose in relation to my instructing solicitors' efforts to ascertain where the closest geographical placement may be, and identifying the Helsham placement as we've put it in the skeleton argument, and the closest potentially available provision. So that's what was said.
54 miles away, but they don't take PACE.
Yes, that's precisely it.
But
So,
sorry, can you clarify then an important point? I thought that was a problem, but then I understood that a place would be identified or approved as secure, and then it would be up to the home itself to decide whether they take PACE people, whether they take only welfare people, whether they take only people from their own area. That's not relevant to the question of approval, is it? That's relevant to what that particular institution decides to do.
well, so this is, I may just be misunderstanding the question. If a secure children's home is constructed in the way many have been, and its object and purpose in compliance with the funding bid, which has yet to be made, but which is set out as an option here, reflects that it's a welfare placement only. Those beds cannot be repurposed. If you have a secure children's home which has 18 beds for welfare placements, 6 beds designated for justice placements, and 0 for 38.6 placements, I'm afraid you cannot use that for Section 38.6.
Who designates it?
So I'm so sorry, if you'll excuse my back for a moment. I think the simplest place to take it, I'm just mindful of the fact that I've given you some rather long-winded answers when you've asked me simple questions. My learned junior, Mr. Jacobs, has quite rightly pointed out that an easy place to find that is paragraph 10 of the Secretary of State for Education submissions below. So that is page 435. Yeah. So in fact, it's 9 and 10. And it makes a cross-reference to the 2015 regulations. I didn't understand this was controversial, but I did see my learned friend, Mr. Underwood, nodding as if to suggest, yes, it could be repurposed and used for section 38.6. So if that's a submission he's going to make, our submission will be it's quite wrong. If you look at paragraph 9 and 10 of the Secretary of State submissions below, it makes clear how the 2015 regulations, which you have in the authorities bundle, we don't have them in the authorities. Yeah. Just give me a moment. We didn't understand this to be controversial because it's reflected in the Divisional Court judgment also, but we don't in fact have those materials in the bundle. If you would be aided by having them, we can provide them. The position is, under the 2015 regulations, by regulation 14.2a, children are admitted to the home only if their needs are within the range of needs for children for whom it's intended that the home is to provide care and accommodation, as set out in the home statement of purpose. Now, the practical trajectory to the home being funded and being created is that a bid is made, there's a procurement process, it details, and this is why the Secretary of State's material provided just 2 days ago explains the capital application and process. By regulation 16 of the 2015 regulations, the statement of purpose must cover the matters listed in Schedule 1 of the regulations, include statement of the range of needs of children for whom it's intended the children's home is to provide care and accommodation, and the criteria. And the important point is this, my lord, at paragraph 10, approval as a secure children's home does not therefore automatically mean that a home is able to accept a referral when secure accommodation is required under section 38.6. It obviously depends not only on availability, but its statement of purpose. And just, my lord...
But automatically is quite an important word. I don't know what that means. And so I'm not trying to be pedantic here. I think it's an important point.
Of course.
But I wouldn't expect, I have to say, if somebody's putting an application in, that they would necessarily focus on pace, because they're going to be very exceptional cases.
Well, it's not about a focus on pace. The issue, this is a rebuttal point, my lord, because what we're dealing with here is we got this statement and this application, and we're looking at the potential relevance of it. Now, it seems to us that, in fact, with this material, the statistics which we've looked at don't add anything other than to confirm the inevitable position that requests for secure accommodation are not being met. And the evidence which is provided in Mr. Phelps' statement, 11th hour statement, about the steps being taken by Waltham Forest to address the problem is frankly far, far too vague to be of assistance to the court. We had that concern when we read it a number of days ago, and those concerns are compounded by the letter from the Secretary of State for Education on the 28th. So what I'm doing is just running through any potential probative value that you may find from this statement. If you were minded to think that the reference to steps now being taken after the Chancellor's spending review update in November 2020, suggesting that perhaps when it comes to issues of relief, you can be assured Waltham Forest have this matter in hand, our submission is that's not right. And what I was doing by going to the 2019 document is, we were rather baffled when we saw this reference. We, like the Secretary of State for Education, took the view that the draft proposal referred to at the second, referred to at paragraph 4. The Secretary of State for Education in the letter of 28th of June says, if it assists the court, we understand the draft proposal referred to is a feasibility study submitted by the Pan London PLPCP to the department in 2019. And that's why we took you to that document.
And you think that's that document?
Well, we don't know. I mean, again, I'm afraid we're in the same position we were in the divisional court. When we've got a situation where, frankly, the evidence you have before you as to what system Waltham Forest has in place is woefully thin.
But I'm sorry, because you've referred a number of occasions to the document being 2019.
Yes.
But the date on it is June June 2019. Sorry, it's the earlier
Yes.
document in that clip that's March 18. Okay.
And for our part, that statement, and we've had very little time, obviously, we haven't been able to ascertain the views of other interested persons, for example, or make our own inquiries because of the time.
I mean, Ms Gallagher, I'm conscious of time.
Yes.
But I mean, we just have to look at the recommendation. The executive is asked to note the work of the steering group and to comment on the proposal being developed. So this is stage one of a very lengthy process, which no doubt, or may well have included, hang on everyone, you've not provided for any section 38(6) in those options, and we just don't know whether as this has been developed and gone forward, there's been significant progress or changes or alterations.
Yes.
And so for my part, I find this, I'm not sure what assistance this really is to me.
Well, that's simply our point. I mean, there's obviously...
Perhaps we better move on then.
No problem. It seems to us it's just too vague to be of any assistance. And in any event, even taking it at its height, and bearing in mind the point my Lord Justice Elias has made, that it's possible that if one of these secure children's homes were in fact created and at a much later stage section 38(6) was factored in, we don't say that's a reasonable system.
Very well, and I think we need to take it.
Thank you. In relation to the material we have before you, our fresh evidence, on that issue, you'll have seen our submissions in the skeleton, and I won't go to that in detail. May I just make three very short points in relation to that? And we rely, of course, in full on our submissions at paragraph 30 to 31. And may I say there's never been an objection to this evidence going in. There was no objection when it was filed at the time, after the oral hearing, and there's been no objection since. And unlike this material, which came to us very late, that material has, of course, it's been pleaded. It was before the Lord Justice Noogie when considering permission to appeal. You'll see in the cost capping order that he indicated this should be left to be dealt with by the court at the substantive hearing. Can I just make three short points? Our submission is that our fresh evidence is materially different to the evidence we've just looked at. A, it corrects a factual inaccuracy in the position presented to the High Court, and which arose from the unhappy position that there was limited evidence before the court about what section 38(6) beds were in fact available to Waltham Forest. And so, diligently, Alex Temple had identified geographically that the Lansdowne Secure Unit in Hailsham, East Sussex, by his calculation, is 56.6 miles from Lewisham Police Station, further from Waltham Forest, and that's why, as we say in 6.3 of our skeleton, as far as the claimant could tell, that was the closest secure accommodation. In fact, post-hearing, thanks to a journalist, we were alerted to that in fact being wrong. So A, it corrects a factual inaccuracy. B, it's central to whether the position is that section 38(6) requests can ever be met by Waltham Forest, because a location which is that distance away may, in theory, be available for a child, for example, hypothetically, on a Friday evening on a bank holiday weekend. So we wouldn't say that's a reasonable system in any event, but it would certainly materially improve the position beyond the true position, we say, in light of Ms. Twite's statement, which is that in fact section 38(6) requests can never be met by Waltham Forest, and that's borne out by the statistics. And then C, we're in the unusual position of the local authority system not being explained by the authority, save for this very late news statement, and we share the Secretary of State's concerns in relation to that, but deciphered and researched by the appellant solicitors. And it seemed to us an unfair criticism about the evidence not being obtained at an earlier stage when you look at Ms. Twite's statement itself. So we'd ask that you do in fact take that into account, and it would be wrong for the court to proceed on the basis that Hailsham is an available unit when in fact it isn't. So against that backdrop, our submission then is, and I will finish by lunchtime, I'm conscious of the time. We've set out our 4 grounds of appeal in our skeleton. And in essence, when you turn to the judgment itself, which is in the core bundle starting at page 49. The vast majority of the judgment is agreed and not controversial. And in fact, much of the analysis about the system operated by Waltham Forest and the statutory scheme reflects the discussion that we've had delving into the materials. The key parts of the judgment are contained in Mr. Justice Andrews' judgment at paragraphs 72 to 78, just page 64 to 65, and then Lord Justice Davis in the short concurring judgment. And first of all, the view is taken by the Divisional Court, agreeing with my learned friend, that this claim is really a complaint about the nationwide lack of secure accommodation available to all local authorities due to the absence of funding by central government. That's what it says in paragraph 72. And that is not supported by the evidence. That's a finding which is not supported by the evidence for the reasons we've given, supported by the Secretary of State for Education's most recent letter, and the absence of a Section 82 application. The second point, which is then made by the court, is at paragraph 75, that it was rational for Waltham Forest to enter into centralised arrangements for the use of existing authorised secure accommodation via the secure accommodation network to operate these arrangements in accordance with the Concordat, and which is also contained in the bundle, to make arrangements to pool its resources with 3 other London boroughs to provide an out-of-hours response. Now, the SAN, the Secure Accommodation Network, is a referral mechanism. So that is simply the means by which accommodation is referred. And there's no issue about Waltham Forest using the Secure Accommodation Network referral system. The issue is reliance upon the accommodation available in the Secure Accommodation Network as it stands in order to discharge its Section 38(6) duty in circumstances where the location of the 15 placements means it never can comply with what's required by Section 38(6). And when Mrs. Justice Andrews says at paragraph 76, Waltham Forest had to form a value judgment about the appropriate use of its resources, our submission is that she was wrong when she said the judgment it formed was plainly one that was open to it, because the judgment formed by Waltham Forest was to adopt a system which means that the answer to any request from a custody sergeant for Section 38(6) secure bed will almost inevitably be no, and it has inevitably been no in all existing cases. Now, our submission, set out in Appeal Ground 3, is that the court erred in all the circumstances in concluding that that system by the respondent is not irrational. Our submission is, unless Parliament fundamentally rearranges the statutory framework, the nationwide lack of secure accommodation, acknowledged by the respondent, acknowledged by the Divisional Court, and indeed reflecting the general position in the case of Ray B regarding secure accommodation generally, including all 3 different types, will never be rectified unless and until individual authorities meet their responsibility to address that problem, albeit jointly with neighbouring authorities. Now, the respondent in our submission places too much reliance on there being a national and centralised system of secure accommodation, and the Divisional Court fell into the same error. Now, at paragraph 29 of the judgment, and this is important context when you then come to looking at the conclusion in paragraph 75 and 76, at paragraph 29, Mrs. Justice Andrews says, in common with all local authorities in England and Wales, Waltham Forest does not own or manage any secure accommodation itself. The provision of such accommodation is coordinated by the Secure Welfare Coordination Unit, which is funded by the Department for Education. That again is factually wrong. It's a misunderstanding of how the system works. The Secure Welfare Coordination Unit does nothing other than provide a common system for referrals. In fact, the majority of secure children's homes which are available across the country are provided by local authorities. 14 of 15 are provided by local authorities, in contrast to what's said at paragraph 29.
Can I just ask, the reference to Secure Welfare Coordination Unit, is that the same as the SAN, or is it something different?
Yes, so the Secure Welfare Coordination Unit is the Secretary of State's, it's the Department of Education's unit. The SAN is the network system. So the best place to find that is in the Secretary of State for Education's submissions below. I think I'll just confirm that this is the best place to find it for you. Yes, I'll give you the reference. The SWCU is described at paragraph 13 of the Secretary of State for Education submissions, page 435 of the bundle. And the SAN, the SAN, is then the system operated with that unit.
Right, thank you.
So they're connected but not precisely the same. I hope that helps.
Yes, thank you.
So when at paragraph 29 of the judgment, Mrs. Justice Andrews says, Waltham Forest is no different to any other local authorities in England and Wales. It doesn't own or manage any secure accommodation itself. The provision of such accommodations coordinated by SWCU, funded by the Department of Education. That's a factual misunderstanding. In fact, there are local authorities who provide accommodation.
Well, if we just take out the bit that says does not own or manage any secure accommodation, is the part thereafter, the provision of such accommodations coordinated by the SWCU, is that right?
No, that's not correct. Because in fact, what the SWCU does, as you see from that reference, page 435 of the bundle, paragraph 13, is it deals with the referral mechanisms. So you've got 15 units, 14 operated by local authorities, 1 operated by St. Catherine's by a charity. The Department for Education has an oversight role. That's why the submissions by the Secretary of State for Education about the role of the Secretary of State are so important. An oversight role for regulating those placements. They're then operated by the providers, whether it's a local authority or a charity, or it could indeed be a private body. And the SWCU is about the referral mechanism. And the referral mechanism is created because you have this shortage and you need to make referrals sometimes to people out of Borough. So the SAN and the SWCU are just the referral mechanism. And it appears to us, looking at paragraph 29 and then going on to look at paragraph 75 of the judgment, where you get the end result. And Mrs. Justice Andrews has proceeded on the basis that it's rational for Waltham Forest to enter into centralised arrangements, which she obviously saw as being precisely the same as all other local authorities, not owning or managing any secure accommodation, and relying on provision made by the Department for Education. Now, when you read it that way, what she then says at paragraph 72 makes sense. Because when she says at paragraph 72, this claim is really a complaint about the nationwide lack of secure accommodation available to all local authorities due to the absence of funding by central government, and you read 72 with 29, and you can see that the court has fallen into error, understanding that this is central government provision, local authorities attempting to access it, central government management by the Secure Welfare Coordination Unit, and that's why in paragraph 72 the blame is put squarely with central government in relation to absence of funding. Now, we and the Secretary of State for Education say there's no proper evidential basis for that finding. And it's an error by the Divisional Court.
I must admit, Ms. Gallagher, it's my fault. I had not appreciated that one of your grounds of appeal is that the Divisional Court made an error of fact.
Can I take you to, it's page 34 of the bundle, Appeal Ground 3, paragraph 7.11, my lord. And
Hold on. Well, I'm looking at your grounds at page 14, because I may be old-fashioned, but I take the view that the grounds of appeal are in a document headed Grounds of Appeal. And is this point at page 14?
So it is our ground three. It's how our ground three has always been put. But let me just check, and I can certainly go back and check the.
Well, ground three is, in all the circumstances, the court erred in concluding that the defendant system is reasonable. I thought that was simply a sort of full-scale attack on the central conclusion of the divisional court, that the respondent had a system which was rational. And I've understood that argument. I had not understood that argument to be that they made an error of fact.
I'm so sorry, my lord. Could you just give me a moment? I'm just trying to get the relevant page. I'm so sorry for the delay, particularly in light of the time.
Take time.
This was accompanied, of course, by, as you'll see from page 9, a skeleton argument with a cross-reference. And it was certainly intended that this be captured within ground 3, and it's always been argued in that way.
I thought it might be captured in ground 1.
Yeah, absolutely.
Yes. Well, I'm bound to say one of the issues, and this is entirely for me, in terms of my drafting, we've obviously created them as grounds 1 to 4, but in fact they collapse and overlap with each other to a large extent. So ground 1 is about the court erring in relation to the finding that this is really a complaint about the nationwide lack of secure accommodation. So certainly this falls within ground 1 in any event. And it falls expressly within ground 3 as we've argued it. I will check over the lunchtime adjournment just to see if I can help you with the background, my lord, or Justice Singh, on that question. And we have always run it in that way, but
Yes,
I'll check. And in fact, I believe when we sought permission from the divisional court, we also ran this point.
Right.
And you'll have seen from the Secretary of State for Education's materials that they were also concerned about the court falling into error on this issue.
Perhaps the sensible thing is for us to rise now. I mean, I'm conscious that you'd hoped to finish your submissions before the short adjournment, but I'm also equally conscious that you've covered all the statutory provisions, so I don't think it's going to be unfair to Mr. Underwood if you just sort of regroup and then make your wrap-up submissions after the short adjournment.
Could I make a suggestion, which I think may save us some time? I'm mindful of the fact that you are likely to have questions in relation to the issue of relief.
Yes.
And in reality, questions in relation to relief I may be best taking as reply points in light of where you get to with Mr. Underwood.
For my part, I would like to know what your suggestions are, and I think Mr. Underwood needs to hear.
I'm happy to do it that way. It's always a danger with saying you'll be short.
I think we're fine. May I ask a question which you can actually ask, think about over the short adjournment? It's not a difficult thing, but when you're complaining about paragraph 29, it does seem to me that she explains that in common with all local authorities. It seems to me if you add the word almost all local authorities, then your alleged inaccuracy falls away, because you'll be able to tell me after the short adjournment how many local authorities there are, but my recollection is it's over 100. And if we're talking about 14 local authorities having their own secure accommodation places, it may be less than 14 because you may have 2 in one particular large local authority. But that all 100 access those 14. For my part, that might put 29 into context.
I can give a one-sentence answer in relation to that. I'll consider it over the lunchtime adjournment, but she goes on to say that accommodation is coordinated by the...
That was not my question.
I'll look at that over lunch. And it certainly is over 100.
Yeah, I'm sure it is.
Freedom of information request.
Oh, right. Well, there we are.
Thank you.
Thank you.
I have the list of questions also.
Yes, but
I'll be as
don't
quick as
worry. I
possible
mean,
after lunch.
if you need probably up to half an hour, I'm sure Mr. Underwood will.
I can certainly be
And
within
we'll trim it off your reply.
Thank you.
Very well. Thank you very much. 2 o'clock, please.
the cafes open, shall we?